morning, the US Supreme Court has ruled that Donald Trump has some immunity from prosecution for official actions taken while he was in the White House. The landmark decision is likely to delay his trial for interfering in the 2020 election. The former president described the decision as a big win. Our North America editor Sarah Smith reports.
The powerful Supreme Court has the final say on what presidents can and cannot do. Today's historic ruling means a president can never be prosecuted for anything that's part of their official duties, but they do not have immunity for non-official acts.
Hi peeps, Adam is here, okay? So, that is exactly what happened the Supreme Court's immunity decision in Trump vs. United States. Trump supporters ran victory laps, declaring the legal threat dead. His opponents warned that the court had made the president a king above the law. And both interpretations missed the most important part of what the court actually did.
The Supreme Court did not say whether all the charges Donald Trump is facing are covered by presidential immunity. So it's going to have to be argued out in a lower court which of his actions were official presidential acts and have immunity, and which were not, meaning he can still be prosecuted for them. Trump is also facing charges in the state of Georgia for trying to overturn the election result there. He phoned a local official and asked him to find more votes.
So, look, all I want to do is this. I just want to find 11,780 votes, which is one more than we have, because we won the state.
The real story of July 1st, 2024 is far more nuanced and far more dangerous for Trump than either side wants to admit. The court ruled 6-3 that former presidents have absolute immunity for core official acts, presumptive immunity for other official acts, and zero immunity for private or unofficial conduct. Zero. None. And then Trump went on television and declared total victory.
The Supreme Court says, quote, the president enjoys no immunity for his unofficial acts and not everything the president does is official, end quote. So a big question here is, when was President Trump acting in his official capacity as President of the United States versus when was he acting as candidate for re-election?
We will never concede. It doesn't happen. You don't concede when there's theft involved.
When President Trump gives his speech at the Ellipse on January 6th and suggests to his supporters to go to the Capitol, is he speaking as political candidate or is he speaking as president? The majority opinion doesn't tell us which. They give the lower courts some quote-unquote guidance, but that will be a key determination as to whether that can even be part of the allegations, even part of the evidence that could be used at trial.
The court's 3 liberal justices could barely contain their outrage. The dissenters said the majority opinion makes a mockery of the principle foundational to our Constitution and system of government, that no man is above the law. Having won from the court nearly everything he could have hoped for, Trump celebrated in a Truth Social post, writing, "Big win for our Constitution and democracy."
His team called it historic. His supporters treated it as the end of the legal threat. But here is what they either didn't understand or didn't want you to understand. The private conduct carve-out is enormous. It is not a small exception. It is not a narrow technical category that applies to a handful of marginal allegations. The fake elector scheme, private conduct, the pressure campaign on state election officials, private conduct, the coordination with campaign lawyers on the plan to prevent certification, private conduct. The conduct around January 6th that prosecutors have characterized as personal political activity rather than official presidential action. Private conduct. All of that. All of the most operationally detailed and most evidentially supported parts of the January 6th and election interference case sits in the private conduct category with zero immunity protection, fully exposed to prosecution exactly as it was before the ruling came down. Trump celebrated a ruling that stripped immunity from the most serious parts of the alleged conspiracy and called it total victory. And most of the coverage either accepted his framing uncritically or focused so heavily on the official act's protection that it missed the enormous private conduct gap that the ruling simultaneously opened. Let me give you the full context you need to understand why this matters. When Trump's legal team first raised the immunity argument in the lower courts, they were arguing for something close to absolute immunity for everything he did as president. a blanket shield that would have made virtually any conduct during his term untouchable by criminal prosecution. That is the immunity argument Trump actually wanted, and it is the argument that the lower court rejected before the case went to the Supreme Court. What the Supreme Court gave him is something considerably narrower, a framework that protects official acts while explicitly leaving private conduct fully exposed, and that requires a court to go through every specific allegation in the indictment and categorize it as official or private before determining what immunity protection applies. That categorization process, the line-drawing exercise that the Supreme Court sent back to the trial court, is where Trump's legal team thought they would find safety because they assumed that a sympathetic trial judge would categorize most of the conduct as official and therefore protected. What they apparently did not fully calculate is how much of the most serious conduct, the fake electors, the state official pressure campaigns, the coordination with campaign lawyers, is so clearly personal and political in character that categorizing it as official presidential action requires a level of legal creativity that even sympathetic judges are going to struggle to justify. The framing of the ruling as a Trump victory was further complicated by something that most coverage glossed over: Justice Sotomayor's dissent. Sotomayor, writing in dissent, warned that the ruling creates a law-free zone around official acts and reshapes the institution of the presidency. She argued that the majority gave Trump all the immunity he asked for, and more for the official conduct categories. But even she, even the most forceful critic of the ruling on the court, acknowledged in her dissent that the majority left unofficial acts fully exposed to prosecution. The most alarmed voice on the court, the justice who was most critical of what the ruling did to executive accountability, agreed that private conduct carries zero immunity under the framework the majority established. That is a significant data point. When the strongest critic of the ruling acknowledges that private conduct is fully prosecutable under it, you know that the private conduct gap is real and substantial, not a legal technicality that prosecutors can easily work around. Let me walk you through the 4 buckets of conduct that the Supreme Court created, because understanding how each category maps onto the specific allegations in the indictment reveals why the most serious conduct is the least protected. The first bucket is DOJ conversations, which the court said are absolutely immune. The reasoning is that the president's relationship with the Justice Department is a core executive function. The management of federal law enforcement is an official presidential responsibility, and subjecting those conversations to criminal prosecution would chill the legitimate exercise of presidential authority over the executive branch. That is a coherent legal theory, and it has real consequences because some of the most detailed evidence of Trump's alleged pressure on DOJ officials to take specific actions regarding the election investigation is now categorically off the table as a basis for criminal charges. That is a genuine win for Trump in a specific and real category of conduct. But here is the crucial thing to understand about why this win does not extend to the categories that matter most. The DOJ immunity applies to conversations with DOJ officials in their official capacity. It does not apply to conversations with campaign lawyers, political operatives, state officials, private attorneys, or anyone outside the official government structure of federal law enforcement. The heart of the fake elector scheme, the pressure on state officials, the coordination of the plan to prevent certification, involved people and organizations that were not part of DOJ, private lawyers, campaign aides, political operatives in multiple states, state-level officials who are not federal employees. All of those interactions, which form the operational core of the most detailed allegations in the indictment, fall outside the DOJ immunity zone entirely. The second bucket is Pence interactions, which the court said are presumptively immune but subject to rebuttal. Presumptive immunity means that interactions with Pence in his official capacity as vice president, including the conversations about the certification process and his role in it, start with a presumption of immunity that prosecutors can try to rebut by showing that applying immunity in the specific context would not impair legitimate presidential functions. That is a harder legal hurdle for prosecutors than the no immunity category, but it is not an absolute shield. Prosecutors who can show that the specific nature of the Pence pressure, the specific demands being made, The specific legal theories being advanced went beyond anything connected to legitimate official presidential functions have an argument for rebutting the presumption. And legal analysts who have looked at this category carefully have noted that the Pence pressure involving demands that Pence take actions that his own lawyers and the DOJ's own Office of Legal Counsel had told him were legally impossible has characteristics that distinguish it from legitimate official consultation, and that could support a rebuttal argument. The third bucket is the fake elector scheme, and this is where the immunity ruling's failure to protect Trump is most complete and most significant. The Supreme Court specifically declined to grant immunity for the fake elector scheme, sending it back to the trial court for the line-drawing determination of which specific acts were official and which were private. And here is the thing. The structure of the fake elector scheme is so clearly rooted in private political activity rather than official presidential action that the line-drawing exercise is going to be extraordinarily difficult for Trump's legal team to win on most of the specific allegations. The fake elector scheme involved at its core coordination between Trump's campaign lawyers, political operatives, and supporters in multiple states to organize slates of fake electoral votes that could be submitted to Congress as an alternative to the certified results. That is campaign activity, political activity. Personal political activity conducted through private legal and political networks, not through official governmental channels, not through the exercise of any specific constitutional or statutory presidential power, not through any official executive branch function. The people involved were not acting in their capacity as federal government employees. They were acting as political actors in a political scheme. And that is the definition of private conduct under the framework the Supreme Court established. The fourth bucket is the January 6th conduct, and this is the category where the official versus private distinction is most contested and where the legal analysis is most nuanced. The broad strokes of what happened on January 6th are well documented. Trump held a rally on the Ellipse, spoke to supporters, and the crowd subsequently moved to the Capitol where the certification process was disrupted. The question the trial court has to answer under the Supreme Court's framework is which specific acts during that sequence were official presidential actions and which were private political activities. The speech itself could potentially be characterized as a presidential communication, the exercise of the First Amendment rights of a sitting president speaking on a matter of public concern. But the specific content of the speech, the claims made about the election, the direction toward the Capitol, the encouragement of the crowd's response, are contested in their official versus private characterization. Prosecutors who argue that the speech was campaign activity rather than official presidential communication have a credible argument that the private conduct framing applies. And the conduct before and after the speech, the calls to state officials, the pressure on Pence, the involvement with the fake elector scheme are even more clearly in private territory. Here is the critically important additional point about the line-drawing process that Trump's team apparently did not fully anticipate when they celebrated the immunity ruling as a total victory. The line-drawing exercise the Supreme Court sent back to the trial court is not a one-time determination that resolves the immunity question forever. It is an ongoing legal process with specific allegations being evaluated one by one, with prosecutors and Trump's lawyers arguing over each category, with the trial judge making individualized determinations about each specific piece of conduct, and with appeals possible from those determinations that will themselves generate additional appellate rulings that further define the boundary between protected official acts and fully prosecutable private conduct. Every time a trial judge rules that a specific allegation falls into the private conduct category, it is a judicial determination that the immunity shield does not apply to that specific conduct and that prosecutors can proceed on those charges as if the immunity ruling never happened. And the more of the detailed factual allegations get categorized as private conduct, which the structural analysis strongly suggests will be most of them, the closer the case comes to looking like what it would have looked like before the immunity ruling, with the most serious charges fully alive and the most detailed evidence fully available to prosecutors. The private conduct gap in the immunity ruling is not a small technical exception. It is an enormous category that swallows most of the most serious and most evidentially supported allegations in the election interference indictment. Every piece of conduct that falls into the private category is fully prosecutable as if the immunity ruling never happened. Here is the core legal reality that Trump's victory lap obscured. He wanted blanket immunity for everything he did as president. He got a narrow shield that covers core official acts plus presumptive protection for some other official acts plus zero protection for private conduct. In the most detailed, most evidentially grounded, most operationally specific parts of the alleged January 6th conspiracy, the fake electors' coordination, the state official pressure campaigns, the campaign lawyer schemes, the personal political activity conducted through non-governmental networks, all of that is private conduct under any honest application of the framework the court established. The official act's immunity is real, but it protects a smaller slice of the alleged conduct than Trump's team publicly claimed, and the private conduct gap covers the most important parts of the prosecution's case. The line-drawing process is dangerous for Trump's legal team precisely because the structural characteristics of the most serious alleged conduct, rooted in campaign activity, private legal networks, non-governmental organizations, make it extraordinarily difficult to categorize those specific acts as official presidential actions without a level of legal creative thinking that courts are unlikely to accept. When a court evaluates whether a specific act was official or private, it is not just asking whether the president was in office when the act occurred. It is asking whether the act was taken in the president's official governmental capacity through official governmental channels in an exercise of official governmental functions. The fake elector scheme was organized through Trump's campaign, a private political organization using private lawyers, coordinating with state-level political actors who were not federal employees, producing documents that were submitted not through official governmental processes, but through the informal political network of Republican operatives across multiple states. Nothing about that structure looks like official presidential action. Everything about it looks like private political activity. And the line-drawing judge applying the Supreme Court's framework honestly is going to have to acknowledge that the private political activity characterization is the most legally accurate one for most of what the scheme involved. The immunity ruling's recognition that ex-presidents can be criminally charged for private abuses of power is itself a landmark legal development that goes beyond the Trump case because it writes into the Supreme Court's precedent for the first time a clear statement that presidential power does not extend to private conduct and that private abuses of the office are fully subject to criminal prosecution. Before this ruling, the question of whether a former president could be criminally prosecuted at all was genuinely unresolved as a matter of Supreme Court precedent. Lower courts had addressed it, but the Supreme Court had never established a clear framework. Trump v. United States resolves that question, and the resolution is not the blanket immunity that Trump's team was arguing for. It is a framework that explicitly and clearly states that private conduct, including private abuses of presidential power, carries no immunity from criminal prosecution. That statement, written into a Supreme Court majority opinion, is now binding precedent. It applies to Trump. It applies to every future president. It applies to anyone who holds or has held the office and who engages in conduct that falls outside the official acts category. The ruling that Trump celebrated as a victory also established for the first time in Supreme Court precedent that presidents are not above the law for their private conduct. Here is what we need to watch as the line-drawing process continues to develop. The trial court's work on categorizing specific allegations, assigning each piece of charged conduct to the official or private bucket, is the most important pending legal development in the entire election interference case, because its outcome determines how much of the indictment survives the immunity framework and how much has to be either refiled in modified form or abandoned. The appellate review of those categorization determinations, which Trump's legal team will certainly pursue for any determinations that go against them, is going to generate additional rulings that further define the official versus private boundary in ways that affect not just this case, but the entire landscape of presidential accountability going forward. And the broader political environment, the 2026 midterms, the composition of Congress, the state of the prosecution under the current DOJ, are all variables that will affect whether the surviving prosecutable core of the case ever reaches trial. The bottom line is this. The Supreme Court ruled 6-3 that former presidents have absolute immunity for core official acts, presumptive immunity for other official acts, and zero immunity for private conduct. Trump declared total victory. The private conduct gap covers the fake elector scheme, the state official pressure campaigns, the campaign lawyer coordination, the personal political activity at the heart of the most serious election interference charges. All of that is fully prosecutable with zero immunity protection under the framework the court established. The line-drawing process the court sent back to the trial court is evaluating each specific allegation, and the structural characteristics of the most serious alleged conduct make private categorization with full prosecution exposure the most legally accurate outcome for most of what prosecutors have charged. The justice most critical of the ruling acknowledged that private conduct is fully exposed. The ruling itself writes into Supreme Court precedent for the first time that ex-presidents can be criminally charged for private abuses of power. The immunity shield was supposed to save him. Instead, it drew a map of exactly which charges can stick. And the charges that can stick are the ones that matter most.